You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Koberg, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence?
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines.
We're going to
many of the
continue
rights
to
that
listen
you
into
have,
this, but Barrett, let me go to you and ask you, what is the document that the judges, oh, we don't have Barrett, so there you go, Lisa, you're on. What is the document that they're talking about that he, has done freely?
It sounds as if there is a questionnaire that asks in greater detail than we are going through in court questions about the underlying crimes and his participation in it, because most of the questions that the judge just reviewed with Bryan Kohberger have to do with sort of two things. One, the adequacy of the representation that he received, and that's to ensure that the plea is impenetrable by something called ineffective assistance of counsel. That's a constitutional issue that many defendants raise on post-conviction appeals, saying basically, my attorney didn't represent me adequately, and as a result of that, my constitutional rights were infringed. He got him to answer yes to a bunch of questions about how satisfied he was with counsel, whether counsel advised him of all his rights and defenses, whether they had done everything that he had asked of them. All of that was uniformly yes. And then he asked him a bunch of questions to ensure he wasn't offered anything other than the plea deal itself to get him to plead, that he was most importantly pleading guilty because he is guilty. He said yes to that. And that he understood that while the plea agreement is a deal between him and his lawyers and the prosecution on the other side, the judge himself is not bound by that. The judge can deviate from the plea agreement with respect to the sentence, even though the agreement between them is that prosecutors are going to seek the statutory maximum for each of the 5 counts against him. That's a burglary count, punishable up to 10 years, and 4 counts of first-degree murder, each of which is punishable by life imprisonment. That's required under the plea agreement, even though it carries a mandatory minimum in Idaho of 10 years on each count.
So that was my question. So what the judge said in saying there will be 4 counts of murder, first-degree murder, fixed life sentences, then later said a mandatory minimum of 10 years. Is there any doubt that he will spend the rest of his life in prison?
I don't think so, particularly given that this was a crime that prosecutors originally said was death eligible. He was also asked, were you promised that I'm going to be lenient on you in some way? And Bryan Kohberger said, no, nobody promised that to me. No one led me to believe that. But the judge is basically saying to Bryan Kohberger, you have a deal with prosecutors that they are going to seek life on each and every one of the 4 counts of first-degree murder here. You understand that is what they are asking for, even though the statute itself carries a mandatory minimum of 10 years on each count. Let's just say, for the sake of argument, even if he did get that mandatory minimum, we're talking about 40 years on the first-degree murder counts, up to 10 years on the burglary count. That could represent the rest of Bryan Kohberger's remaining life, even if we don't have a life imprisonment. But I do think the chances are greater than average and probably almost near certainty that he is going to get life in prison without parole.
I was interested in the form that the judge was talking about because I wondered, is it possible on that goes beyond what he said publicly in court, if it could answer possibly some of the questions that Kaylee's dad has?
I think, Chris, what's most likely going to be on that form is the basic facts that are necessary in order to satisfy the elements of the crime. It is possible that we could hear the judge read this into the record and ask these questions on the record. But as a matter of not only having the record through the stenographer, but having a written document that has been reviewed and signed and the signature confirmed by the judge, this is sort of a backstop to dot all I's and cross all T's to make sure that this allocution is airtight and cannot be appealed because of how clear it is.
Ann Taylor, who is Kohberger's lawyer, is a public defender. A lot of questions were asked, as Lisa just pointed out, if Bryan Kohberger was satisfied with his counsel, if everything was explained to him. What is the conversation like when you go to a client and say a plea deal is being offered, and helping them to understand why there might be a reason to take it?
Well, the first thing is you have to communicate any deal to a client. Any offer that comes from the other side, you have to communicate. And so you come to them hopefully you've set expectations with the client going into the case in general in terms of where do we want to be? What does this look like? And so you'll compare the original expectation that you set with whatever it is that they're offering, and then discuss any factors in between that have maybe changed.
When you say expectations that you've set based on what you know the evidence is that the prosecution has in the case.
At that time, correct. So walking into the case, you may set one expectation, and as discovery is revealed and shared and exchanged, you may say, you know what, this case is not as strong as I thought that it was against us, or this case is much stronger than it is, and our case is really, really weak. So we need to adjust this. And so as you're presenting these things to a defendant, you have to make it very clear, this is your choice. I cannot make this choice for you. I can only advise you as to the possibilities of what may happen. I cannot make you any guarantees. You have to understand this is your choice to make. I'm simply here to advise you as to you being your counsel, how to go about this, how to think about this, and perhaps what our options are if you do not take this. And so clients will say, should I do it? Should I not do it? I can't answer that for you. What I can tell you is, based off of the facts, the circumstances of my experience, I think this is a good deal, or I think we may be able to get you something better. But if you decide that you do or don't want to take this, I can't make that decision for you. It's your choice.
And as the judge says, you are not free to argue and you waive the right to appeal. Charles Coleman, Lisa Rubin, Jay Gray, thank you all